mid-19th century, commercial law across the Indian subcontinent was an uncoordinated patchwork of local customs and religious edicts. That changed when a single, unified statutory framework was drawn over the territory. This framework is Act No. 9 of 1872, the Indian Contract Act. Upon its passage, it became the definitive baseline for all commercial agreements in India. Drafted during the British colonial era, the Act took the fluid, unwritten principles of English common law and converted them into strict statutory rules designed to govern Indian commerce. The Act received the Governor-General's formal assent on April 25, 1872. It officially came into force later that year, on September 1st. The shift from decentralized custom to a rigid code and the eventual deconstruction of the Act's original 266 sections defines how Indian commercial law functions today. This historical evolution establishes the jurisdictional limits of the modern Act and its role as a foundation for all subsequent commercial statutes. Before 1872, there was no single legal code to dictate how a promise would be enforced. The colonial administration navigated a divided judicial system, with the subcontinent split between major urban centers and the vast surrounding territories. Inside the presidency towns of Calcutta, Bombay, and Madras, courts applied English law under an authority derived from a royal charter in 1726. The dense shipping traffic in Bombay Harbor illustrates the scale of maritime trade that operated directly under these English commercial principles. Outside those major port cities, in the regions known as the Mofussil, disputes were settled according to justice, equity, and good conscience. This meant British judges applied basic English common law precedents on an ad hoc basis whenever specific local laws were absent. When local rules were available, courts defaulted to the personal laws of the communities involved, applying Hindu or Muslim law based on the religion of the defendant. In these traditional marketplaces, agreements were honored through social norms and religious guidelines rather than a uniform legal text. This patchwork of contradictory jurisdictions meant a single transaction could face different legal outcomes depending on its location, a level of uncertainty that stalled mid-19th century trade. A growing economy required absolute contractual certainty. Merchants needed to know exactly what made a promise legally binding, regardless of the territory. The Imperial Legislative Council was tasked with unifying these fragmented rules into a single comprehensive statute. Lawmakers achieved this by translating the fluid, unwritten precedents of English judges into explicit statutory definitions. Principles like free consent and legal capacity were distilled into the code, providing a clear checklist for valid contracts. This new act was secular, overriding decades of reliance on religious and local customs for commercial disputes. Its passage marked a shift from fragmented pluralism to universal statutory uniformity across British India. The original architecture of the Act was massive, consisting of 11 chapters and 266 sections. It was designed as a complete commercial code, housing general principles alongside rules for specific domains like partnerships and the sale of goods. By the 20th century, commercial transactions grew too complex for these broad strokes, necessitating a more specialized legal structure. The first major excision targeted the rules for commercial goods, removing sections 76 through 123 from the main body. These were replaced by a dedicated Sale of Goods Act in 1930. Chapter 11, covering business formations in sections 239 through 266, was also extracted. This became the Indian Partnership Act of 1932. This new code drew heavily from the English Partnership Act of 1890, providing more exhaustive rules for modern firms. The current Indian Contract Act is a truncated version of the original, focused on general principles and specific contracts like indemnity, bailment, and agency. Even so, the Contract Act continues to function in a supplementary capacity, filling gaps whenever the specialized acts of 1930 and 1932 are silent. After India's independence in 1947, the Contract Act was retained as a federal law. It now applies across every state, with its core 1872 text largely intact. Its longevity is a result of its doctrinal elasticity, a set of principles broad enough to accommodate new technologies without breaking. Legislators in the era of the telegraph wrote a framework that successfully governs 21st century e-commerce. This adaptability was demonstrated during the legislative updates of the year 2000. The Information Technology Act surgically amended the historical code by inserting Section 10A. Section 10A grants formal legal recognition to electronic contracts, ensuring a digital agreement is as binding as one signed on paper. This single update allowed India to validate digital commerce without writing a new contract code from scratch. The Contract Act endures by codifying the universal principles of human consent and obligation, logic that scales across 150 years of commercial evolution.